I want to discuss the case that just came down today, West Virginia versus B.P.J. This is commonly known as the opinion about allowing biological males who might identify as female to play in women's sports. Specifically, I wanted to talk about what exactly the court held in this case. A lot of times I'll read news articles about what the opinion, summarizing what the opinion was and giving us a shorthand version of what the court held. And I often find that those news articles are incorrect. So as someone who interprets Supreme Court decisions on a nearly daily basis, I wanted to share my perspective. The court has a number of good quotable material in here that I might be looking at my computer to pull from and read to you. But I'm going to start with what I find most interesting about the opinion. So the opinion was written by Justice Kavanaugh and joined by 5 other justices. This really, I don't think, is a surprise to anyone who follows the Supreme Court. So Kavanaugh wrote for the majority, and he was joined by Roberts, Alito, Gorsuch, and Barrett. And we see Sotomayor and Kagan and Jackson concurring and dissenting in part. But the majority decision was held by 6 justices. Again, not a huge surprise to most followers of the Supreme Court. What I found interesting in this opinion is how Kavanaugh was not shy to say things like, as all agree. So for example, as all agree, females and males have inherent physical differences relevant to athletic performance. Just as someone who reads on these topics a lot, I don't think everyone agrees on that. I think you can find a wide variety of articles where people don't agree on that. I've had private conversations where people say, men and women, there is no biological distinction between them. They should be allowed to compete. So Kavanaugh comes right out and says some of those things, like as everyone understands. So another thing I found interesting about the decision is that Kavanaugh really does a lot of writing about how important sports are, which I think is really interesting. I think people that play sports and watch them would agree with him, but I think that there's a lot of people that don't necessarily kind of share his zeal for the topic. So, as a reader, I appreciate, the zeal that he put forward there. So to start with, what was the holding of the case? So the holding of the case was that states are free to prohibit biological males from competing in women's sports. That was the ultimate holding. States are free to do that. Specifically here, it was West Virginia and Idaho, but the opinion makes clear to point out that 27 states have enacted laws like this. There were 2 different plaintiffs in the case, and I think that the distinctions between them are kind of interesting. One of the plaintiffs was a boy who transitioned to being a girl in 3rd grade, whereas the other one, Hecox, who's now an adult, so their name is listed, Hecox, that person didn't transition until much later in life, apparently underwent male puberty, and did not transition until college. So the distinction between those 2 plaintiffs, the dissent talks a little bit about, but the majority doesn't do much discussion of. I think there's quite an argument to be made that those are 2 different kinds of plaintiffs. So moving on from there, some other interesting things in the opinion are I'd like to quote some of the quotes that the court gives about, why they found the way they did. So separate sports teams for biological males and biological females are reasonable. Given the inherent physical differences between the sexes, allowing only biological females to play on women's and girls' teams can reduce the risk of physical injury and ensure fair competition. The court returned to these subjects over and over again. So number 1, that allowing boys to play with girls increases the risk of physical injury to girls. And then separately, the court repeatedly talks about fair competition and how allowing boys to play on girls' teams necessarily is pushing, number 1, some athletes out who might not make the roster now that this boy has taken the spot, or that girls might be discouraged from joining teams where they know that boys are going to be allowed to play because they might be afraid they'll get hurt. Moving on from there, some more interesting things about the opinion. What struck me was the court mentions that Title X or Title IX authorizes separate men's and women's sports teams, and that's always been the case. And so from the court's point of view, their decision today is really not a revolutionary one. It's one that matches the history. Title IX was passed in 1972 and interpreted to apply to sports in 1974. So they do make the point that sex meant nothing more than biological sex in 1972 and 1974. Another interesting point from a legal perspective is that the Hecox plaintiff made a point during the pendency of the litigation to put in a statement to the court that they no longer intended to compete in women's sports. I think there's been some articles written about why that decision was made by that plaintiff, but what the judges held was that too bad, you can't do that. Number one, we don't believe you might not change your mind again, and number two, even if that's what you think right now, it could change. Apparently, this person is still enrolled at Boise State University. So again, going back to what Kavanaugh writes as being undisputed propositions, again, like I mentioned earlier, I think a lot of people do dispute these propositions, but he writes, the states start with the undisputed proposition that biological males generally possess inherent physical advantages in sports in height, weight, strength, speed, endurance, jumping ability, and the like. And that these laws excluding biological males from playing with girls help prevent serious physical injury, number one, and preserve opportunities for female athletes to fairly compete and succeed. We see those two interests asserted over and over again in the opinion. Moving on from there, the dissent makes some pointed criticisms of the majority, and Kavanaugh responds to those, essentially trying to say, let's keep this polite there towards the end. I think the most important legal point here, or constitutional point really, is, Kavanaugh says these are hotly debated issues, and the legislatures of each state are more well-positioned to make the law on these matters than we are. Our job is just to determine if there's been a violation of Title IX or a violation of equal protection guarantees in the U.S. Constitution. Kavanaugh points to decision-making that's recently been done apparently by the International Olympic Committee, the U.S. Olympic Committee, the NCAA, all of which have made the decision to exclude biological males from female sports. The court ends with kind of trying to reiterate how simple they believe the holding is. Justice Kavanaugh writes, the Equal Protection Clause allows schools to maintain separate teams for female and male athletes. Schools may determine eligibility for women's and girls' teams based on biological sex. That policy is constitutionally justified by the vitally important interests in safety and competitive fairness so as to provide equal opportunities for women and girls to participate in sports. What really struck me was these lines at the end where Kavanaugh talks about, basically, I think, making the argument for why is this an opinion of importance. He writes, some might ask, what is the harm in allowing an additional athlete to compete in women or girls' sports? That sentiment, though understandable, misunderstands the nature and reality of sports. Sports are highly competitive and generally zero-sum. At almost every turn, someone wins and someone loses. Every athlete who makes a team takes a roster spot from another athlete. Every player who earns playing time reduces the playing time of a teammate. Every player who makes the starting lineup sidelines another who remains on the bench. Every competitor who wins a race or competition deprives another athlete of that victory or medal or prize. Every team that wins because of an added player means that another team has lost because of that added player. Every player who makes all conference beats out another player who does not. Every student who earns an athletic scholarship takes that opportunity away from another student, and so on. He goes on to write about basically the joys of sport, or the benefits of sport. He writes, women and girls who play sports care deeply about all of these things. They obsess about them. They spend extraordinary time and effort to train in the heat and in the cold, to work out early in the morning and late at night, to get a little faster, to become a little stronger, to jump a little higher, to shoot a little better, to watch a little more video, to make the lonely journey back from an ACL tear, to scrap for playing time, to start, to win the game, to win a championship, to hang a banner, to bring home a medal, to be all tournament, all county, all state, or all American. They put a championship trophy or all league award on their bedroom shelf, and it stays there forever as a reminder of their love of the game and pride in their achievements. They learn to endure losses with grace, to lift up their teammates, and to respect opponents who have beat them fairly and squarely. They learn to win with class, to look a defeated opponent in the eye, shake her hand, and congratulate her on her effort. Whether the star of the team or the last player on the bench, they form lifelong friendships and lifetime memories. They savor their athletic accomplishments and cherish them for years, even decades after their playing days are over. He goes on to write that women deserve an equal playing field without fear of physical injury from biological males or being forced to compete against biological males. The Constitution and Title IX do not require an overhaul of women's and girls' sports throughout America. Let me know if you have any questions.